So yes, we're going to talk about the CARE Act, we're going to talk about debt recovery. And as we know, the CARE Act brought in significant changes in the way that local authorities recover adult care and support charges, and also the way you deliver those services. And a lot of the focus and coverage has been on some of the core changes, so how the wellbeing principle is interpreted and how it rolls through your policies and procedures, how you deal with assessments, both needs assessments, financial assessments, how the new deferred payments agreement process works and how it's going to be implemented. There has been very limited coverage on the debt recovery element and how you should approach debt recovery and the strategies that you adopt in order to support the good services that you deliver. But debt recovery is really important, and the numbers, some of the numbers that we can see from some relevant organisations indicate to us just why they're important. I'm a lawyer, so numbers are not my forte, but we'll go through some of the key numbers that you will have seen probably in documentation and some of the websites available. So the Addai budget survey indicates that the social care overspend for the 16-17 financial year was £366 million. The Local Government Association, in their budget forecast for 2017, suggests for every £1 of council tax collected, over 38 pence of that will be spent on adult social care. And that figure is considerably up on the 2010-11 figure, which was about over 20 pence. Of course, they've predicted that the local government funding gap by 2020 will be £5.8 billion, and the funding gap for adult social care alone in 1920 will be £2.3 billion. So it's clear that there is a funding need in this area, and I'm sure you've all grappled with that issue and will continue to do so. But as well as increased need for funding, the predictions are the needs are going to grow in our communities as well. So again, the LGA by 2025 are predicting that a further 350,000 vulnerable or elderly people will have high needs care. So it's clear that not only is central government going to have to put hands in their pockets and add some funding, solve some of the issues that we'll face, but also local authorities are going to have to maximise their income. And that's going to be for a range of ways, but also including debt recovery. And getting your debt recovery strategies correct from the outset is going to assist you to be able to deliver your frontline services. So what I wanted to do was have a look practically at some of the issues that you may face during debt recovery and implementing some of those principles. And starting off, looking at a topic that is very significant, the interrelationship between social workers and the social work team and debt recovery. So many of you would have read the guidance and would have read the suggestion that debt recovery as a function perhaps should be embedded within the social care team. Now, interesting suggestion in the councils I've spoken to, it isn't one that's being adopted wholesale. It may be something that comes in later in time. What's clear, irrespective of where the debt recovery function sits, the role of social workers is fundamental to your debt recovery strategy. And I'm sure many of you have had conversations with your social workers and have dealt with the fact that they are very busy, they've got a very important role to undertake, and getting them to focus on the financial elements and debt recovery elements historically has been a challenge. And it can be a challenge because, understandably, their focus is on needs and meeting those needs. And my argument to social workers has been the same for some time, but I think has been bolstered by the wellbeing principle. And that is, it is really important to get the finances right, to ensure finances are managed from the outset and throughout. Because if you do that, you can prevent debt from occurring. And if you prevent debt from occurring, you stop the need for debt recovery action and someone horrible like me having to chase an individual to pay debts. It's not controversial to say a debt recovery process, whether it's through the courts or even if it doesn't get to court, is a stressful process. So for me, it is really important for social workers to buy into the process and to understand that debt recovery is vital to prevent and look after the well-being of the individuals themselves. It's vital that the communication between your social work team and any finance team is strong and good. And that communication has to be two-way. So for social workers, they need to be updating you as finance officers about any change of circumstances. And that is change of circumstances not only that will impact whether or not the person's liable to pay charges at all, but also whether or not they are in a circumstances to be able to pay the sums that they are liable to pay. So an individual who's gone into hospital for an extended period of time, the finance team needs to be informed of that so that you can make adjustments on your debt recovery process and you don't necessarily steam ahead with action when the individual's not necessarily in a position to pay their debt. But it is two-way, and so from a finance perspective, it's really important that you give your social work teams as much information as possible, and that means keeping them abreast of what debt situation exists on the case. The worst thing to have is to get to a situation where you've got a debt of 20, 30, 40,000 pounds and the social worker dealing had no idea that the debt had accrued because you've missed an opportunity to resolve that case. A good social worker who's informed about a debt accruing is in the best position to try and understand why the debt has accrued and to establish whether there are things that can help to resolve the situation. Another issue for me that's really important that I would ask you to pass on to your social work teams is documentation, and they are in the front line, and so they speak to family members, individuals, and have conversations that can be critical and really important later on down the line. I'm sure you have all had cases where an individual has said, no, I'm not liable to pay because the social worker said it's all free. And you obviously have to deal with that objection. It's so much easier to deal if your social worker has made a note of the conversation and they clearly have indicated what discussions have been had about fees and charging, etc. And that can be provided as evidence to the other side. But also, they're in a privileged situation that they may be party and hear conversations that will give you indications about assets that exist, about how those assets may have moved around or the intention behind moving those assets. And so any information they have might be critical, particularly on some of the higher value and complex deprivation cases that might come subsequently. Now, the Care Act allows for assessments to take place at a distance, and you don't necessarily have to do face-to-face assessments. Where it comes to debt recovery, I found that it can actually be really useful to have face-to-face dialogue with the individual in question. And that dialogue can help to break down barriers, understand the obstacles for payment. There are limitations on your resources, so historically some of you may well have set up regular meetings with your individuals in your community when doing assessments, etc., but the resources don't allow for that necessarily any longer. Judge and Priestley have set up a service where we can provide joint client visits with local authorities, in which one of our trained team would attend and visit on individuals and their next of kin, alongside a social worker, ideally, but also potentially a finance officer, and have those face-to-face, sometimes difficult conversations about liability and payment and why payment has to be made. And we found those visits fairly successful. One of the very important things to do and to establish before going anywhere with recovery action is whether or not your customers, your clients have mental capacity. And this is something that will determine what route of action you can take. Because if someone does lack capacity in terms of legal proceedings, I may still be able to issue proceedings and sue them, but I need to get a litigation friend involved. And so action is limited. And also, is it going to be effective for me to keep sending letters and trying to call for someone that doesn't really understand what I'm asking of them? So understanding the mental capacity situation of your client is critical in your debt recovery process. And I would ask you to ask yourselves, what is the feedback that you get from your social workers about mental capacity? How often is this being tested, and how often is it being fed back to the finance team so you understand what's going on? And if the answer is it's not at all and we don't know, that is a process that you're going to have to look at and ensure you've got better visibility about capacity before taking action. It has to still be done. The numbers tell you that debt recovery must be a core element of what you're doing. It's about getting the approach right. In my view, those instances, and indeed the guidance suggests, and the Local Government Association have affirmed this approach of rejecting security where there is a first charge, I think it leads to a problem, particularly in the absence of HASSASSA. There are a number of individuals that will have very good security, so very small mortgages on their property, if anything, be sitting on properties in London that could be worth $500,000 or more, and yet you're rejecting deferred payments agreements because they don't meet the strict criteria. And actually, because of the absence of HASSASSA, you may be getting yourselves into a situation where you're having to do more work than you would have otherwise had to do. And we'll see that when we talk about the HASSASSA charges and the loss of them. Is insolvency a viable option where a debt is undisputed? Potentially. I mean, it is something to consider, particularly if you have a suspicion that there has been transactions with the individual to third parties where monies have moved away, assets and property has moved away. Bankruptcy may be a way of having some of those transactions properly investigated and reversed. So it's an option to consider on a case-by-case basis. Section 70 of the Care Act deals with deprivation of assets, and I just wanted to flag it briefly because the current situation in the media, the fact of avoiding paying for care charges has never been higher profile. Think not only about your standard cases and your standard debt recovery matters, but those cases where you have suspicions that assets have moved away. Documenting, understanding the position, working with social workers is going to help you to be able to not only understand those cases, but take them forward and potentially recover some money back. So, we talked about the broad debt recovery approach and changes, and one of the big losses, I think, that the Care Act brought in, it was the loss of the HASSASSA charge. And for a lot of local authorities, and I as well, when you saw the rules and the changes, that was the biggest thing that stood out for me. Now, as you know, Section 22 of HASSASSA allowed local authorities in certain circumstances to impose compulsory charges on a client's property. It was a very simple process. The charge is created by a statutory declaration and then it's registered at the land registry. There are obviously processes that you had to follow in advance, ensure that there was an outstanding debt, you had to have demanded a debt, but broadly that allowed you to get good security for your debt. Was it a useful tool? Absolutely. So the HASSASSA charges applied, of course, to residential care, and those are the kind of charges that tend to accrue at the fastest and the highest rates. It provided a really neat solution for those clients that refuse to pay after having a demand, those people that refuse to pay, refuse to engage, where they had a property. It gave you a really neat solution and avoided the need to litigation. It gave you substantial security as well. As we know, HASSASSA charges were essentially abolished from the 1st of April in the sense that no new HASSASSA charges can be created. The transitional provisions allow for where there is existing HASSASSA charges and debt continuing to accrue, those debts can accrue on the existing HASSASSA charges, but no fresh HASSASSA charges can now be created. And that poses a real difficulty for local authorities. What was the justification for the abolition of them? Well, it was felt that HASSASSA charges were unilateral, and they absolutely were. They gave a local authority a significant power to impose a charge without the other side really having any way of resisting it. the argument is Section 69 provides equal protection for both the local authority and the individual in the debt recovery approach that it provides, and gives the individual an opportunity to seek an alternative means of making payment. My argument would always be that they always had an alternative means of settling the debt. They could have just paid or engaged with the local authority and entered into alternative form of charges or payment arrangements. So that I think there was always alternatives. There were negatives of HASSASSA charges. So there were some local authorities that were using them in inappropriate circumstances and not always following the correct processes. The HASSASSA charge was a really good tool of getting your debt secured, but it almost led to people forgetting about the cases, forgetting about the debt. And of course that meant that underlying disputes weren't being dealt with. The great difficulty is that you put a charge on the property, you think, great, that's done, let's move on to the next case. 10 years later, you come back to try and redeem that charge, and the family start questioning, oh, we don't think we're liable to pay the charges at all. Yeah, but there is limited reason for mortgage companies to refuse, even where you have to get consent from a mortgage company to, I mean, on a HASSASSA charge you didn't, but even if you needed to get consent to put a second charge on, the mortgage company can't refuse that consent. They have to act reasonably, and where there's masses of equity in the property, they're not going to do it. And so it can still be really good security. And so taking a very strict approach can lead you into problems. And so how do you get over the problem of HASSASSA and solve it? Well, having a robust process in relation to your debt recovery and ensuring that you flag the issues before they escalate is really important. That goes without saying. Maximising engagement with your individuals, getting social workers to buy into the process and getting that engagement, giving detailed consequences of detailed explanation of the consequences of non-payment, utilising client visits to try and broaden the engagement you have with individuals is all important and might assist to bridge the gap. But ultimately, if you don't have a DPA and you don't have engagement, you're left with having to potentially do serial litigation, because if I issue proceedings, obtain a charging order that can absolutely secure the debt against the property, that's only for a finite sum. Your debt is still accruing. So I'm back all over again in 6 months, 3 months' time, having to go through the process again. More costs, less comfort for the individual because they're going through the legal process again. So for those reasons, I would encourage you to look at your policies and think about whether you should expand them. And there are no doubt risks of doing so, but you've got to see the other side of the coin. The other thing it's really important to do to minimise the effect of the loss of HASSASSA is to deal effectively with lack of capacity cases. So we'll talk about lack of capacity in more detail, so I won't touch upon it here. The other thing I wanted to look at is releasing secured debt and asking the question whether it's time to enforce. Now, it's a really good time, I thought, when the HASSASSA charges were abolished, the local authorities to take stock and look at what you've got in your portfolio of HASSASSA charges. And if you haven't been reviewing them on a regular basis, this is the time to sit back and see what you've got. So ask the question and review your cases as to whether or not your charges are valid. So was the original process effectively followed? Review how much of your debt is actually secured. Look at what your debt values are, do revaluations of the property. Does the property still have equity to cover you for any ongoing charges? You might have individuals that are going to set to live happily, hopefully they do, for 10, 20 more years. Have you got enough equity to cover you, and what are you going to do when it runs out? Also, significantly, what's the condition of the property? Because an individual who has a property that's left vacant and no one's living in it, who's maintaining the property? Is it actually being insured? You've secured significant funds against the property, but you've potentially put a massive risk on your cases if the value of your property is depreciating because no one's maintaining it. These are the questions that you need to consider. It's also, I think, a good time to have a look at your charges, because we know we're in an economic situation where the property market seems to be changing and moving. And looking at the Royal Institute of Chartered Surveyors October 2017 UK Residential Market Survey, they say that demand and sales are softening. So we've operated for a number of years on the policy and the approach that property values are only going one way, and that's up. So in that kind of market, your HASSASSA charge is a little less risky because the equity hopefully is rising higher at a higher rate than your debt is. There's a flat price trend across the UK, and significantly, the respondents to the survey suggested that London and South East are reporting negative trends. If this property bubble bursts, all of a sudden, if you're sitting on millions of pounds worth of secured HASSASSA debt, that millions of secured debt that you thought was good may not be good debt. So it's worth reviewing and thinking, is it time to now enforce the charges? And I pose a question, should the approach be consistent with DPA charges? And what I mean by that is, should the HASSASSA charge be for life? My view is generally, yes. In most cases, it's not unreasonable to have that approach as long as there's enough equity and there is no other reasonable way the individual can pay the debt. But there will be cases where it's inappropriate for a HASSASSA charge to sit indefinitely. Particularly where the scenario I've highlighted, where properties are left empty and vacant and no one is looking after the property and are actually depreciating in value. Is it now time for you to act not only in your interest but in potentially the other side's interest, the individual's interest, by realising that property value and taking out the equity? There is risk with that approach. Selling a property leaves you with potentially surplus funds that you'll have to give back, and it's easier for those surplus funds to be depreciated. And so if you've got someone that's going to be in care for a considerable time afterwards, you've got to know how they're going to fund the care thereafter. Are they going to spend all of that money and come back to the local authority and say, well, now you've got to pay for my care, I've got nothing left? So those are the factors that do need to be considered, but it's really important to have a proper review of your HASSASSA charges. Lack of capacity cases, and really one of the most difficult areas that you will face in relation to debt recovery. The Alzheimer's Society estimate that 80% of people who enter care homes have dementia. And so if there isn't an immediate lack of capacity, it may well be something that gradually occurs over a period of time. As you know, capacity and the capacity to deal is dealt with on a decision or task-specific basis. So we're particularly concerned with their capacity to deal with their financial affairs and also potentially their capacity to deal with legal proceedings if it comes to having to take action to recover against them. And those are the questions that you have to have in mind when dealing with debt recovery. You do need to have an effective process in place for determining capacity on a regular basis and recording those assessments. So there are often cases that I will see that there are initial capacity assessments, but then years and years go by and you've got no evidence of anyone really looking and examining an individual's capacity. And that is actually hindering your debt recovery. As I said, if you've got someone that lacks capacity and you're writing to them thinking you're trying to get an engagement with them, you're potentially wasting your time. Establishing capacity all the way through, as well as what's going to happen when someone loses capacity, is vital. I mean, there are a number of key issues. You might have a situation where someone lacks capacity and there's someone formally appointed representative and they're failing to pay the debts. And if you've got someone formally appointed, great, because if necessary, if that person's not dealing, beyond potentially reporting them to the Office of Public Guardian, there are steps you can take to take legal action in order to recover the debt through. There may be more complicated situations where you've got next of kin and third parties that are managing finances informally. So they can be absolutely innocently seeking to manage their family members' affairs, but haven't taken the formal steps of getting a lasting power of attorney or deputyship. And those can be the more challenging cases, because once some of those individuals confronted with the question of debt, some of them will shy away from responsibility. They don't want to get involved. They don't want to be pursued. So it is really important, as I say from the outset, to try and get those who are dealing informally to be put on a formal basis, so there is proper oversight and regulation. We were talking earlier about whether or not there is that regulation of even formally appointed deputies and attorneys, and there's a big question mark there. But at least if there is a formal documentation, there's a formal appointment, you're on better ground. And then there are situations where there's no one actively managing finances at all. So either there is no family member or friend around, or there's no one that's willing to deal because they've got busy lives, and understandably they may not want that responsibility. The council has to consider its obligations on safeguarding, and those obligations are specifically mentioned in the Care Act, and I think Section 42. And so the question of capacity not only has to be identified, but also considering whether or not the lack of capacity is creating a risk situation from a safeguarding perspective, particularly in those informal arrangements where family members and friends are managing finances and maybe helping themselves to funds. And it may be a scenario where daughter, son takes a view, well, look, these are assets I'm going to get when mum or dad passes away. I'm struggling financially at the moment. I'm going to help myself out a bit, and mum wouldn't mind. And the likelihood is that's absolutely right. Mum probably wouldn't mind if you're struggling, but there is an obligation to pay the debts. So monitoring safeguarding and having both social workers and finance team tied up on that is really important. Whilst no one's effectively managing finances, a debt is accruing and assets may be dissipating. And those are the worst kind of cases that I see, that where the debt's been accruing over years and there was money, there was good money, but it's all gone and it's gone to third parties. And although there can be avenues of trying to get that money back, it is never an easy case. So prevention is always better than cure. Start getting in at the front end is the way to go about it. If someone is not engaging with you, there is often a risk that there's a reason they're not engaging and there's a safeguarding issue that's going on. So those situations shouldn't be ignored. If the next of kin is failing to engage and you have to start making a decision on whether it's for the council to take out an application for deputyship, it is not necessarily a short process, but think about what steps you can take to protect income in the interim. So is there an appointeeship in place? Does the DWP need to be notified that that needs to be changed to a local authority officer? Because if the income's still going into either a third party or going into mum's bank account, someone potentially still has access to that. So think about how you can protect the assets in the interim until you've got a deputyship order in place. Where there is an next of kin that's unwilling or unable to take the steps necessary, then it's time for the council to consider what you can do. And so making an application yourselves to appoint a council deputy is always, in my view, a good option. I say that resources comes into play again, conscious that with limited resources, your ability to be appointed across a broad spectrum of cases becomes more challenging. Should you be seeking the appointment of an alternative court-appointed deputy if you can't and you don't have the resources? If you're going to make the application, ensure your social workers are aware of all the information they need to gather for the application. Often this responsibility is placed on social workers. I'm not sure whether it's completely fair to put the entire burden on them. It can be difficult to get asset information, financial information, particularly from someone that's not engaging or hasn't got capacity. So think about what are alternative and out-of-the-box options that you can take to keep your application moving forward. So can you make interim applications to try and gather information about someone's finances, access to their bank accounts, so you know actually is a full deputyship worthwhile? Manage your application process effectively. So the Court of Protection, as busy as all courts are extremely busy, it's worthwhile keeping on their case, chasing applications through and not leaving them to die a death in the corner somewhere. Really important that you're proactively managing the process. And if you don't have the internal resources to deal with this, think about outsourcing it, either outsourcing the process entirely or outsourcing part of the process to give you assistance. Because although that in itself creates work and moving work outside, if you don't have a proper solution for lack of capacity cases, you will be losing money because assets will be dissipating and you won't be able to recover your debts back.